Madam Chair, I don't think I've ever had a hearing before where a Supreme Court decision drops at the same time. So we're like real time trying to figure this out. And I know that you're sitting here and you haven't read the opinion, but Professor Carrier, what do you make of at least the top line of the Supreme Court's decision that just came out 5 minutes ago?
Well, actually, I did read it, thanks to phones, and I think it is a very positive decision. It was unanimous. It made clear that certain types of conduct, at least in this case, did not lead to a finding of induced infringement, but there still is a different role for Congress to play. If I were the brand firm, I would go back to the Wayback Machine and find one tiny piece of evidence that the Supreme Court didn't talk about, file another lawsuit, and we're off to the races. The Supreme Court, even though it was unanimous, cannot act with the certainty that Congress can. The Supreme Court also only applied to one context, not the biosimilar context. So I still think even today's decision does not displace the role for Congress.
So maybe a step, at least according to your opinion, maybe a step in the right direction, but Congress, we can't punt and say the Supreme Court has already
Exactly.
this. Okay.
Yes.
What, Ms. Simpson, you discussed major changes to patent laws related to generic competition in the 80s and the 2010s. You also discussed how investment in R&D has shifted from Europe to the United States in the last 50 years. How has balancing patent rights for inventors and generic competition affected U.S. investment trends in the biopharma sector?
Well, as I mentioned, I think these laws really transformed the United States into a place that attracted investment, and it brought the biopharmaceutical industry here. And those were laws that were largely passed in the 1980s. And since that time, and most recently, I'd say over the last 10 to 15 years, through things that Congress has done, and especially the courts have done, have in a number of ways dramatically weakened patent law. And I think we might not be seeing the effects yet, and this is not specific to the biopharmaceutical industry, this is across all industries, but it's providing a real opportunity for other countries to take the lead. And China, most notably, has been filling in the void. Not only have they strengthened their domestic patent system, but as an economy that's largely state-driven, they've just been investing money. And as I laid out in my testimony, they're making real moves to try and take the biopharmaceutical industry from us using both state money and their patent system. And our country relies on the patent system to fuel investment. And that's why I think taking any measures to further weaken the patent system on top of what's already happened in the absence of strong evidence would be a mistake.
You hear that, Ms. Good? Do you think, just broadly, do you think our patent system is too restrictive? I think Ms. Simpson obviously has a different view of that, but do you think it's too restrictive for generics and biosimilars?
So with the Ethic Act being pro-innovation, these patents that are duplicative, they would not issue without terminal disclaimers. They would be rejected. But terminal disclaimers make it easy to flood the market, flood the system with these duplicate patents. When we talk about China, we should think not about the quantity of American patents, but we should measure American innovations by the quality of its patents. And this is what the Ethic Act goes to. So,
Professor Carrier, what role do you think that intellectual property policy plays in promoting that competition? Obviously, we've got these 3 bills that we've talked about a little bit today, but what role do we have in promoting that competition and lowering prices relative to other factors like PBMs or insurers, regulatory barriers?
The pharmaceutical system is incredibly complex. And there's more than enough blame to go around. There's blame to be placed at the feet of the PBMs. There is blame to be placed at the feet of drug companies. The legislation here would be really helpful because the Hatch-Waxman Act was designed to be a compromise between promoting generic competition and fostering brand firm innovation. There was a lot in Hatch-Waxman for brand firm innovation, patent term extension, 30-month stays, and all that. It's just the stuff on the generic side, now the ladder is pulled up behind them when, for example, they try to get rid of skinny labels. So we're trying to restore that balance.
I'm trying to, last question, just want to make sure I get it, and just to boil this down, you know, the Compromise Act that was created that we're operating under, is it your belief that pharmaceutical companies have used that and then maybe structurally or procedurally use it to game the system to get a monopoly by another way? Is that kind of what you're articulating at the time?
Time has
to
expired, but you may answer.
Yes to all of the above. Hatch-Waxman has been incredibly successful in certain ways. Look at the percentage of generics on the market. Hatch-Waxman also has been gamed. It's not just me that says it. Hatch and Waxman themselves have said that the system has been gamed.
Thank you for that, Mr. Chairman. I yield back.
I thank the gentleman.